Thank you, Chairman Whitfield, Ranking Member Rush, Mr. Barton, and other members of the subcommittee. My name is Bill Cooper. I'm the president of the Center for Liquefied Natural Gas. Thank you for this opportunity to present my views on the regulatory barriers to LNG exports. The Department of Energy has issued two exceptionally well-reasoned orders in the Sabine Pass and Freeport cases, which Assistant Secretary Smith, I'll abbreviate his title, Assistant Secretary Smith referenced in his testimony. Both of those orders adhered to the statute, DOE's rules and policies, and the rulings DOE has previously established in its orders it has issued. Such orders provide regulatory certainty to the community of the regulated, and I certainly commend them for their good work. When DOE makes a decision on an application, it is a good decision. The problem is there's no certainty as to when DOE will make a decision, and its effort to establish the order in which it will proceed is unlawful. Effective December 5, 2012, DOE published its Order of Precedence, the Q, informing the public as to the manner in which it would process the 15 applications pending before it and all subsequently filed applications. Preference was given to the pending DOE applications that had received approval from the Federal Energy Regulatory Commission to use the FERC pre-filing process in the order the DOE application was received. All other pending and future DOE applications would be processed thereafter in the order of filing at DOE. Even with its attempt to provide procedural guidance as to the order in which it will consider the applications, DOE did not provide any timelines as to when those decisions would be forthcoming. After 15 applicants reasonably relied upon the only rules DOE had published, DOE changed those rules by predicating when it would consider each application, not based upon when those applications were filed at DOE, but based upon when an applicant filed with another agency, and DOE announced that decision after the fact. While many may argue about the conditions of the queue, namely when an applicant filed with FERC or whether contracts should be in place, that is not the issue. The issue is the establishment of the queue in the first place. For if it is accepted that a federal agency can amend its rules by agency decree and apply those amendments retroactively, there could be no end to the process and no regulatory certainty. The result would be an agency repeal of the congressionally mandated Administrative Procedures Act. DOE's issuance of its order of precedence for the queue is unlawful for the following reasons. Number one, the establishment and use of the queue is in essence an amendment to the rules promulgated by DOE as set forth in Title 10 of the Code of Federal Regulations, Part 590, and therefore is subject to the same notice and comment requirements as the original rules. Notice of the queue was not published in the Federal Register with an opportunity for the public to comment. The failure to provide such notice and comment renders the queue void. Any amendment to an existing rule cannot be applied retroactively, thus rendering the queue ineffective as to the 15 pending applications at the time of the queue's issuance, even if the queue was properly issued, which it was not. DOE should acknowledge that the queue was not properly issued and should proceed with its determinations of all pending applications based upon its lawfully established rules. With the queue being void, it cannot be applied even to the applications filed after the announcement of the queue. DOE should proceed with its determinations of all pending applications within a reasonable time from the closing of the time period set forth in the Federal Register. The mere passage of time does nothing to add to the evidentiary record upon which DOE must base its decision. That evidentiary record closed when the public comment period closed. Any federal agency should adhere to its rules. No matter how noble the intentions of an agency may be, placing retroactive duties upon applicants when it is too late for those applicants to do anything about it undermines the rule of law, the need for regulatory certainty, and the demands of justice. Thank you for the opportunity to present my views today.